Hello, everyone joining. We are just going to let some folks come in and let the participant numbers jump up. So just give us a few brief moments before getting started here. We will be talking about concentrated animal feeding operations tonight with Adam Voskuil, an MEA staff attorney. I'm seeing the numbers still tick up, but I will go ahead and get started in that today we are operating in Zoom webinar format, meaning attendees cannot see each other, but you can see panelists, so such as myself and Adam. Tonight for questions, if you have questions, please submit them through the Q&A box, which is located on the lower portion of your screen. It says Q&A. You can submit questions at any point during this presentation, and we will try to address as many as possible following Adam's presentation. The other note is you can send a chat to the hosts and panelists, but you cannot send chats to each other. So that is the Zoom etiquette for tonight. It is a pleasure to turn it over to Adam for him to start his presentation. Thank you for joining.
All right. Thank you, Hannah. Just looking for a thumbs up or something that everyone can hear me.
Good. You're good.
Perfect. All right. Thanks everyone for joining tonight. As Hannah said, my name is Adam Voskuil. I'm a staff attorney at Midwest Environmental Advocates, and I focus a significant portion of my work on agriculture and agricultural issues, particularly in the state of Wisconsin. So before jumping into the specifics of the webinar, just a bit of background on Midwest Environmental Advocates and who we are. MEA is a Wisconsin-based nonprofit environmental law center, and we started in 1999. So we've been around 24 years at this point. I had to check the calendar. And so we work with communities to develop strategies to take action, to respond to threats to land, air, water, as well as the broader communities that rely on those resources. Now, as a law firm, that certainly can and does take the form of representation and litigation, but it also means we hold events like what we're doing tonight. We also publish guides and provide other resources, and we run a relatively robust intake line where folks from around the state or even kind of the broader network of Great Lakes regional states can call with concerns or questions, and we are happy to provide resources or insight where we can. So really, we try to take that collaborative approach and raise the floor of knowledge for all individuals across the state. And really tonight is meant to continue that effort. And so the purpose of holding today's webinar is to inform communities, interested members of the public around the state that are dealing with or really may deal with concentrated animal feeding operations in the future. I've found that similar concepts or similar concerns are often raised by people that have never met in different areas of the state. And this venue seemed really as appropriate as any to introduce myself, introduce those concerns though, and maybe answer questions and at the end facilitate some discussion on those issues. Our power is often really, it reaches its peak through a collective voice or action. And certainly we don't need to be aligned on every issue on all topics. But I'm really hoping that this webinar kind of can serve as a primer to really give everyone the same tools and the same information so we can have that collective voice and really be more effective in the future. So let's start with those base concepts to kind of discuss that primer. And so I think, like I said, to start, it's really important that we're all using the same words to better understand each other. And so a CAFO, as Hannah said at the beginning, is a concentrated animal feeding operation. And it is, there's a picture of one in the screen there. It is typically characterized by a large number of animals, oftentimes the same type of animal, right? Like a beef CAFO or a dairy CAFO. And all those animals are housed together often inside for a requisite certain amount of days of the year. And the waste from those animals, be it manure or other wastewater that's kind of created through the process of operating that CAFO, is stored oftentimes almost exclusively in large manure lagoons. So if you're still looking at the picture, it's in the bottom left. You can see one right there, the dark box. Those lagoons can be lined, they can have earthen structure or clay underneath them, but they are still, in all of those instances, essentially pits in the ground that hold that waste until it is, getting to that third point, spread on fields. It can be trucked out or pumped out, and then spread on agricultural fields around the area. And then finally, if we're talking about a uniform understanding of the verbiage, an animal unit is something that comes up quite a bit when we're talking about concentrated animal feeding operations. And for those of you that don't know, an animal unit is an official kind of regulatory legal-based term that's used as a way to standardize or kind of make sure everyone's on the same page for the size of what an operation is. It's a different number that's associated with a different type of herd or animal type. So for example, a beef steer, right? One beef steer is the equivalent of one animal unit. Similarly, a milking cow one milking cow is worth 1.4 animal units. So it's a bit tricky, but a CAFO in Wisconsin is defined as, or a large CAFO is defined as 1,000 or more animal units. So under that kind of example, you would take 1,000 beef steer to reach the threshold of being a CAFO, whereas it's close to 700 milking cows. So fewer animals, but the idea is that because it's equalized by the amount of waste produced, 700 cows kind of meets that same threshold mark. And I've seen a couple chats come in. I'm happy to answer more questions about it either at the end of the call today, or if people want to reach back out, I'll probably say that a few times. This was meant to be a relatively basic slide, but it already gets technical and it will continue to be so. And for that, I apologize. It's just kind of the nature of the beast, so to speak. So moving on to not just CAFOs more broadly, but to CAFOs in Wisconsin. Yeah, I have a bit of an old graph on the left, but what we've seen is an expansion of CAFOs in Wisconsin. We used to say recently, I think we've to some extent passed that mark and can now say in the last 20 years, we've seen a significant growth of CAFOs in the state. As of April of last year, and I apologize for not having a bit more recent data or number, but there were 327 CAFOs in Wisconsin. And it's not just the rise in numbers, but also the regional or the geographic proximity that can sometimes raise concerns for communities that are left to respond to or deal with concentrated animal feeding operations in their community. And so that map on the right, I think does a good job, as it's meant to, of showing where those operations exist. And so you see they are, while spread out in some respect, you can see certain pockets where there appear to be more operations. Certainly in that what we call the Northeast section of Wisconsin, that's Kewaunee, Brown, Manitowoc, Fond du Lac County, kind of right along the thumb. You see a collection, an aggregation of those CAFOs. And then you can also kind of roundabout up on the northwest portion of the state see more. And like I said, certainly there are more in between, and they all pose concerns for the communities that are living adjacent to or down gradient of or downwind of. But the aggregation of those CAFOs also similarly pose concerns when there are a whole bunch of pollutants being stored or spread in an area. And so moving along, I think now it's a good opportunity to talk about why folks care, right? It's not just that those operations exist. It's that they do pose threats or concerns for communities that, like I said, live down gradient, downwind, downstream, adjacent to. And this is a really simplified version of what those concerns are. And certainly there's been a suite of studies. There's been a number of, it's not just anecdotal evidence, but a lot of peer-reviewed research from all across the United States and the world of what those concerns are. But I'll briefly go through each of these, and I touch on drinking water contamination and air quality decline in following slides as well. But to begin, drinking water contamination is a significant concern as it relates to CAFOs. A large portion of our state rely on private drinking water wells that may be next to or down gradient from where that manure and processed wastewater is spread on farmland. And the concern is that waste or contaminants from spreading may seep into the groundwater and into the aquifer and navigate to those groundwater wells. And so we see things like nitrates, as I said, or bacteria contaminating groundwater and by proximity or kind of by the way it transports private drinking water wells for households. Moving to surface water degradation, again, to serve as a primer for a lot of this information. I'm moving a bit fast, but runoff from fields. So the stuff that doesn't transport down to the groundwater can be flushed off often from those fields into surface waters, to streams, to creeks, to ditches that eventually make their way to lakes or streams or rivers, leading to excess phosphorus. So we've got nitrate and bacteria in groundwater, but we have phosphorus in the surface waters, and that phosphorus serves as food for algae, creating oftentimes or in some places like toxic algal blooms, which in turn leads to fish kills, a significant number of fish dying off as a result of no oxygen in the water. I'll touch on air quality in a bit, but the two of the primary concerns health-wise are hydrogen sulfide and ammonia, but there are a number of other contaminants that pose concerns for communities. And then these last two are kind of, particularly the property value question or threat, is one that's tied to another concern, which is that we've seen studies that show that things like groundwater contamination or private drinking water well contamination can lead to a depreciation or diminishment of property values because there's potentially unsafe water at the area. Those studies have also shown, though, that remediation of the water or removal of that threat of contamination, or if it's minimized, those values can actually rebound as well. So there is some hope, but it is a threat or a concern that's posed to a number of folks that live around the state in communities that may be grappling with these issues. And then finally, increased truck traffic. So all that manure has to go somewhere, and oftentimes what are used are hauling trucks, semis that are driving along roads, and there's so much manure that a lot of trucks are required, and there's more traffic than the roads were typically meant or had historically been dealing with. And so what you'll see degradation of roads as well due to the heavy weight and the increased traffic on those roads. And oftentimes it's occurring at such a pace that local governments are unable to respond, in a timely fashion to remediate them or can't fix them quick enough as they're degrading even further. But in addition to the increased truck traffic and degradation of roads, we've also heard concerns about high volume of traffic, noisy traffic, those hauling trucks driving, single file down a road, and people counting dozens of trucks spreading manure on adjacent fields, for an entire day. And so, like this slide kind of starts to get to the concerns of the community are valid. They're also very broad, and they touch on a lot of different things. And so it's important to at least have this primer, but also recognize, like, I can't, my slide couldn't include all of the concerns, but these are the primary ones that we hear about. So moving to some of the specifics to give a bit more of some analysis, I guess. So when we're talking about drinking water contamination, for the most part, we're talking about nitrates or bacteria. In Wisconsin, nitrates are actually Wisconsin's most widespread groundwater contaminant. And the extent and the severity of nitrate groundwater contamination is or has been and is increasing in the state. So we've seen that it is getting worse. And in addition to that, studies have shown that around 90% of the nitrogen inputs to groundwater can actually be traced back to agriculture. So to some extent, we also know the source of that contamination, not the specific entity, but kind of the broad category of source. And it raises concerns for communities because there are health effects associated with nitrate contamination. Pregnant women and young children are certainly the most susceptible to those adverse effects. The one that's most commonly discussed is blue baby syndrome, which is a bit more technical than probably any of us want to get into, and my knowledge allows, but I do know that it is very traumatic and life-threatening. And it is characterized by, as the name would imply, a baby that is born with a bluish tinge or hint. But it's not just young children and pregnant women. Exceedances in nitrates have been tied to things like thyroid disease and cancers, most notably colon cancer. Separate from nitrate, we've also seen things like bacteria contamination, things like E. coli showing up in folks' wells, and again, causing stomach concerns, causing significant health effects as well. And those are all oftentimes transported from land spreading fields into groundwater and then being transported in that aquifer to an adjacent private drinking water well. And I'll just note that the Wisconsin's Groundwater Coordinating Council does a really good job of putting out an annual report every year, identifying the status of groundwater and additional threats or concerns that communities may be faced with. And I think it's a really good resource to check out if you're starting to think through some of these issues and getting a grasp on not just the specifics of a potential proposed CAFO, but also the science. And I think Hannah will be able to provide a link to that in the chat. So moving on, like I said, it's not just drinking water contamination. I'm not going to go through all of the concerns, but the second one is air pollution. And I really include this slide for a couple reasons. One, I really like my brain kind of functions in spreadsheet format. So I like the visual here. But I just want to note, there's hydrogen sulfide, there's ammonia, there's also methane as a greenhouse gas, which has been a concern. And I think the big thing to emphasize here are both the health concerns, which there are, physical body health concerns like headaches, respiratory problems, eye irritation, nausea, things like that are associated with these air emissions for folks that live adjacent to or nearby CAFOs. There's also mental health issues that have been tied to living adjacent to these facilities and kind of in this type of air quality. And that's, negative mood states, depression, anger, and also there have been some ties to neuropsychiatric issues or abnormalities, and that's been impaired balance and memory. So all that to say, the concerns associated with air are widespread. They include physical body concerns as well as mental health issues. And I always like to include this slide and this talking point to note that this is not, as sometimes is characterized, just like typical farm smell. Oftentimes we'll hear the concerns be minimized, the concerns of the community be minimized as you're just not from, rural Wisconsin or the country. And, these are just the smells you live with. And that's not the case. There are real health concerns and they extend beyond unpleasant odors to actual illnesses or ailments that one might have. So that's why I include the slide other than just the visuals. So that gives, I think, like I said, a good primer as to CAFO prominence in Wisconsin and the concerns that communities often have. I really want to spend the rest of the time discussing how CAFOs are regulated. I will note again, this can get technical, but there's really not a way around it. And I hope that in the future, if you gain some knowledge from this, but also know that there is some organization that you can turn to, that MEA can continue to be a resource in the future. So what we see for how CAFOs are regulated is this tiered system, for lack of a better phrase. CAFOs are regulated under the Federal Clean Water Act. It's kind of the basis for the typical regulation of CAFOs in the nation. However, EPA approved, the Environmental Protection Agency approved Wisconsin's version of a Clean Water Act in 1974, basically saying, you take charge of our permitting program that we would administer under the Clean Water Act. And instead, you permit those entities in the state under Wisconsin's WIPDES. So that top arrow from the state, the Wisconsin Pollution Discharge Elimination System program. From here on out, I'll be calling it WIPDES because it's just quicker. But that is kind of the preeminent way that you see CAFOs regulated in the state. How CAFOs spread manure is addressed via, and so just to say, that's kind of the end of federal oversight or federal regulation for CAFOs for the purposes of this presentation. And so moving to state, in addition to that WIPDES program, which is the implementation of the Clean Water Act for CAFOs, we also see regulation via runoff management and CAFO spreading of manure in a different administrative code. And then the livestock facility siting law, which has been in the news recently, and some folks I'm sure on the call are aware of. And then moving to the final method of regulation, we see local ordinances, local zoning. Certainly some of that is the implementation of livestock facility siting, but there are other avenues as well, and stuff that I'll get into later in this webinar. Things like operations ordinances, things like manure storage ordinances at the local level. So this is, again, just a good primer to understand the different levels, and we'll break into those more specific in a bit. So WIPDES permit, as I said, it is the most prominent way that you see CAFOs being regulated in the state of Wisconsin. Every large CAFO, which, as I said, are those with 1,000 animal units or more, has to apply for and receive a permit from the Department of Natural Resources. That permit is intended to address the discharges of contaminants, things like phosphorus or nitrate, E. coli, bacteria, things like that, to waters of the state. And that's in quotes, waters of the state. It's an official phrase defined in Wisconsin law. And though it is a relatively long laundry list in state law, I typically think of it to mean including surface waters and groundwater. So those permits are meant to address and in some instances, or in many instances, prevent discharges of contaminants to surface waters and groundwater in the state. So that kind of outlines its importance. Let's maybe dig into some of the specifics of the application process. I apologize, other than the air contaminants slide, this is the slide that has it's the most word heavy slide. But I think it's important to kind of understand all the things that go into the permit application and all the things that come out of the permit. I won't walk through each of these individually, but I'll try to touch on some of them as we talk through this. I use this slide as a prompt for myself to understand the timeline for an application. It's not cut and dry the exact same for every permit, but considering it is to some extent similar for most, and it is the primary opportunity that local communities have to get involved, we're going to spend a good amount of time on this slide. About 6 months to maybe a year before a permit is sought to be approved and issued by the Department of Natural Resources, or DNR, the overseeing agency, the applicant, so the proposed CAFO or the CAFO, if they're already operating, will submit an application to the DNR. That application will include things like an environmental analysis questionnaire, as well as a nutrient management plan, things like the engineering specs for and plans for any construction that they'll be doing. It's a significant list of documents that accompany an application, a calculation of how many animal units they'll have, so to say. And so that application is reviewed for its completeness by the Department of Natural Resources, the DNR, and then once they determined it complete, they start reviewing the application and drafting a draft permit. DNR's review can take months. During that time, those resources, those application materials are available online. I think Hannah's providing a link to them a bit later in the call. But they're public documents that can be reviewed by interested members of the public at the same time that DNR is also reviewing them or drafting a permit. Following that review, DNR will issue a notice of a draft permit. And this is kind of where it feels like the rubber really meets the road for a lot of communities that are interested in responding to CAFOs in their area. That draft permit, as well as a couple supporting documents, will be available on a website that DNR runs called I've always called it the WIPD's Permits on Public Notice site. It's maintained on DNR's website, and I believe Hannah's posting a link to that right now. We're relatively link heavy, but stay with us. That website will include the draft permit, right? The actual document that the black letter law that a CAFO will need to follow if they're operating. It includes schedules that they have to submit additional documentation, or limitations on discharges to groundwater, or a lot of boilerplate terms as well that are kind of found and required for WIPD's permittees. In addition to that draft permit, which certainly any interested community member should review, there's a notice, which is usually a 1 to 2 page document giving notice to the public that they can comment on this permit. They can submit written comments to a named DNR staff member that's in that notice. And then the third document that's often submitted is a fact sheet, which is anywhere from a 30 to 60 page document typically, that kind of provides the underlying reasoning for including a number of the permit terms in the permit. It also will identify the water that the facility may discharge to, or the amount of volume of manure. It really is it's a good resource to dig into the specifics of the facility, because you won't really get that from the permit itself or the notice. So like I said, it's really where the rubber meets the road. There's a 30-day comment period, typically following the publication of that permit on the website to be provided, or that's been provided, I hope. And in that 30-day period, members of the public are invited or empowered to provide comment to DNR in written form. And that's typically, the entirety of the process, but it is not always the entirety of the process. In addition to issuing written comment, DNR also has, there are also some provisions that allow for a public hearing on a permit. DNR has in some instances noticed their own public hearing, but also there is, like submitting comments, the public is empowered to make a request or invited to make a request to DNR. And I believe it's if 5 or more individuals ask DNR to hold a public hearing on a permit, DNR has to, but DNR has the discretion for fewer, if 1 or 2 folks ask for it, DNR has the discretion to still order a public hearing. And these days, in the virtual world that we live in, public hearings are typically held via Teams, Microsoft Teams, where folks can call in and they can talk through. They're usually given 3 minutes or 5 minutes, and they can talk through all of the concerns that they have. There are DNR staff on the line listening and taking notes. And those comments are given the same weight as written comments. You are not limited to doing one or the other. You could certainly do written comments and oral testimony. Sometimes, if people really want to provide attachments or really dig into a very particular issue, it's a lot easier without a time limitation to do written comments. But that is not to say that there isn't value in also presenting. After the close of the comment period, and again, stick with me, we're jumping on to soon. DNR reviews all the comments and the comments in relation to the permit as well. And there is no firm deadline by which they then have to make a decision or issue a permit. Certainly I've seen as quick as a few weeks if there hasn't been a lot of public engagement, but many months as well has been a result if there are a whole bunch of comments that DNR has to consider and respond to. But after a certain amount of time, after a certain amount of review, DNR typically issues a notice of final determination, which is a document in which they respond to they organize the types of comments and the specific concerns of comments and then respond to those comments, and also the final permit as well that would go into effect. And that was a really quick run through of maybe a year's worth of regulatory process. So everyone's eyes can unglaze over. We're going to move forward now, but just to say it's pretty intensive. And there is, at the very minimum, 30 days where the public can really dig into and provide comment on specific issues, specific permit terms. Like I said, the public is empowered or invited to really engage in that portion of the process. And MEA has been, is able to help. We've got the CAFO guide online. And in some instances in the past, also ourselves will provide comment on CAFO permits. So what happens after a final determination if a CAFO receives the permit and the public or the broader community or in some instances MEA determines that it's inadequate, right? Certainly has happened. We've been in the news about it a couple years ago, actually. So there is a method for challenging that final permit. But I want to caveat this right at the start, and our guide makes mention of it as well, that it's an exceptionally technical process with a lot of, I think they're necessary, maybe not necessary hurdles, but there are hurdles built in that may make it challenging for members of the public to go through an entire administrative hearing without representation. So as such, this is kind of where our guide stops. I'll just provide a really brief talk through of it before jumping into local control. But a challenge, an administrative hearing, or as we typically call it, a contested case hearing, is initiated by, for our purposes, a petition from 5 or more interested individuals asking the DNR to disagreeing essentially with the DNR's permit, noting that a specific provision in the permit doesn't comply with state or federal law typically. DNR reviews that petition, which does have a deadline that must be submitted to DNR. They review the petition for adequacy, making sure that it complies with their own requirements, and eventually, assuming that it does, passes it along to a different state agency where an administrative law judge starts to oversee the case. The administrative hearing itself is largely functions or is similar to a court hearing or a court case, with briefing from the parties and introduction of expert testimony, which is why I said there's some value in considering whether legal representation may be beneficial. I think one thing to note for the purposes of this meeting or this webinar is that in addition to it functioning like a court hearing, there are some key differences. And the one that I really want to dig home on is that if it gets to an actual hearing, the public is also given in a contested case hearing an opportunity to comment on the proposal as well. So if 5 interested individuals go through the contested case hearing process, once you get to sitting in front of an administrative law judge, other members of the public can also chime in and voice their concerns or issues. And certainly we've seen that be valuable actually in the past. And to highlight one of the times that I've seen it be valuable or understand it to have been valuable, we go back to 2014 when an administrative law judge declared at the time DNR's CAFO program a massive regulatory failure and ordered in a case that MEA was representing Kewanee individuals and ordered groundwater monitoring at land spreading fields and an animal unit limit. Many of you may have heard of this case. The official title of it was Clean Wisconsin v. DNR, but it's also been termed the Kennard Farms case. That went all the way up to the Supreme Court. And in 2021, they affirmed the decision, ultimately finding that DNR had the authority to include those terms that the ALJ issued. So that groundwater monitoring or land spreading field monitoring, as well as the animal unit limit. And I think one of the important things is, there was a significant amount of public comment at that hearing in front of the ALJ about the experiences that folks in the community had with brown water or water contaminated by coliform or E. coli, and the lack of trust in their own private drinking water wells. So all that to say, it's a technical process, but the public gets to still be engaged if one goes to challenge it. And certainly MEA is willing to or able to provide resources or information as we're able along the way. And that gets us out of WIPD's permitting. And I realize I'm already probably running a bit long, but I do want to touch on a couple issues of local control. Moving outside of the state regulatory realm and into what local governments are doing and can do. And so to start, I think it's appropriate to begin with livestock facility siting. And this map is an indication of where livestock facility siting is occurring in the state of Wisconsin, either via licensing or zoning based on the green or red designation. But to zoom out a bit, in the early 2000s, the Wisconsin legislature directed not the DNR, a different department, the Department of Agriculture, Trade, and Consumer Protection, to develop default standardized requirements for the siting or expanding of livestock facilities. That's the official, siting or expanding of livestock facilities. And a couple years later, 2006, I believe, DATCAP did just that. They issued regulations. And I don't have time to go wholly in depth to what those regulations say, but just to note that they are meant to be and are a singular uniform thing that in its entirety, for the most part, local governments can adopt for livestock siting, right? There are other means, but if a local government is going to adopt livestock siting and regulate the location or the siting or expanding of livestock facilities, this is the set standard that local government can choose from. And those regulations cover the location of livestock structures, odor and air emissions, nutrient management, manure storage facilities, and runoff management. Those are the 5 subcategories that you find in the regulation. I'll note that oftentimes people find those regulations insufficient to really protect their interests. And that regulation does provide for an opportunity to pass more stringent laws. We rarely see it taken advantage of, but I'll use some air quotes here. Local governments are empowered to create stricter requirements for CAFO operations. Those requirements, though, need to be reasonably and scientifically defensible findings of fact, and the standards using those findings of fact must be necessary to protect public health and safety. And again, I use those air quotes because that's the exact language. And some of you may note like that has some broadness to it. There's not been a lot of helpful guidance to really nail down what that means. What is a reasonable finding of fact, or what is necessary? And certainly different sides can have different viewpoints on that issue. But I think, from our perspective, it's always best to favor the actual health and safety of the community. And certainly there's been a suite of data, a whole bunch of peer-reviewed studies, as I said earlier, that really support certain restrictions or limitations based on the really good science. But local governments are expected to interpret those words alone. And at the same time that they're tasked with interpreting what that means, what those phrases mean, they're often receiving threats of litigation from industry groups, certainly somewhat related, but just a few years ago in a county in Wisconsin, as they were considering extending a temporary CAFO moratorium, industry groups actually sent a letter alleging that the members of that county board could be subject to felony charges for voting in favor of extending that moratorium. So all that to say, there's a lot of external pressure placed on these small local governments as they're considering options. And so it's hard. We understand it's hard. And oftentimes, like, local advocacy does play a really important role in kind of pushing that forward. There may be questions on kind of the process of the rule. It started to undergo changes this year. It's really early on in the process, and I would say to learn more on kind of how the livestock facility siting rule may be updated, I would look to MEA's website in the coming months as I'll be tracking this, and just recognizing that I'm running a bit short on time tonight to really dig into those specifics. So now we're on to a different form of livestock regulation, or CAFO regulation, and it's something that's a bit less known about. It's a bit newer. And that's operations ordinances. Certainly there are other means. I talked about manure storage ordinances, but this slide is really meant to dig in and highlight operations ordinances. We've seen them in Bayfield County, and then we've now seen a number of townships in Northwest Wisconsin also adopt CAFO operations ordinances. And I pulled from one of their findings of fact, I pulled this because I think it really it highlights the concern that those folks have in that area. But in the instances of adopting operations ordinances, the towns are really relying on their authority to protect the public health and safety, to regulate day-to-day operations, not, as the livestock facility siting law says, the siting of livestock facilities, but regulating those day-to-day operations of the facility. As I noted, to date, operations ordinances have been adopted in a few places, and in all of those instances, they are supported by significant findings of fact that are just meant to really show the need for these ordinances, to really protect the community that would be living adjacent to, or downwind or downstream of these CAFOs. We're really early on in the process. I'll note, because there's probably, I think there's been some news on it, that there is currently litigation occurring as it relates to one of these towns' ordinances. But we're really optimistic and really look forward to seeing what happens going forward, because I think that this is it's a good step for towns to start feeling empowered to address the concerns of their communities. And so with my last maybe minute or two, I just want to end with discussing the ways that you can get involved, right? This has been a lot of me throwing knowledge at people, or throwing information or regulations at people. And I want to take a step back to really talk about where we see a lot of the help from communities. One of the most impactful things, as I just said a bit ago, is local advocacy, seeing folks in their own communities step up and organize, reach out if they have questions to MEA, but also push their local representatives, or their state government, or their state representatives, or members of the DNR. Typically, as I said, they're the ones that do whip these permits. Getting involved in the review process of application materials, right? All of that stuff starts with local advocacy, building a groundswell of support for a movement. And when you have more eyes and a more unified voice, I really think it can go further. Moving on, sampling and testing. I've seen certain areas of the state really get into developing drinking water well testing programs for people to test their own wells, or engaged, as you can see in the picture, in surface water sampling. If there's not a CAFO in the community, it provides a really good baseline to really understand the susceptibility to contamination and also the current quality, something that you'd want to protect and want to highlight if there are concerns of a proposed CAFO coming in the future. Monitoring and oversight kind of are similar to the points of sampling and testing. As I talk about surface water sampling, we see volunteers or citizen science efforts offer that baseline data and really be valuable. And I think they can lead to, if there's already a CAFO in the community, the information that can be used to support things like rehabilitating a private drinking water well, right? If you test it and it's over a certain level, particularly for nitrates, the Department of Natural Resources has just expanded their well compensation program to cover nitrates. I think we'll probably post a link to there for those of you that may be interested. And then the last thing that I really wanted to highlight is asking questions. Ask questions of the DNR, ask questions of me, ask questions of your local representatives. One of the best ways to start making change is to understand the issues fully. I go through life thinking there are no stupid questions anywhere. I know people sometimes say it in an academic setting, but really the only way that you're going to learn and the only way that you can start engaging in that local advocacy is through asking questions. And one of the easiest ways to do that, as a perfect transition to my last slide, is your right to open government. In addition to our CAFO guide, MEA has also published a public records guide or an open government guide. And I think don't just ask questions, but also find the underlying facts and documents. There's an addendum to that point. Don't just ask questions, find the documents as well. I think the guide serves as a really good primer to understanding this law as well. Certainly read it, but also the Department of Justice has provided an open records guide and an open government guide. And it's a valuable way to hold your represented officials, your local governments, DNR folks, DACAP folks, state officials accountable. I know I kind of breezed through the last few slides. I see that there are a lot of questions and I'm happy to start answering them if Hannah wants to pass stuff my way.
Yes, for sure. Thank you so much, Adam. I know you covered a lot of information, and I will be honest with folks, we will do our best to try to answer as many questions as possible. We're going to try not to go over 8:05 for timing, so hopefully we don't go over. But again, please use the Q&A box. That is what I will be looking at for questions. I am not looking at the chat at this point. So again, that is on the lower portion of your Zoom. It is a Q&A. It has two bubbles, little text bubbles. So please use that to submit your question. We are trying to answer some questions by text, by writing the answer. So your question might be listed as answered if we've already addressed it. So again, Q&A box. And Adam, I'm going to have you stop sharing the screen so people can just see you and me and really focus on the information. So our first question, I'm actually going to answer. I found it out, but what do the orange triangles on the CAFO map represent? And that's from an anonymous attendee. And it's actually the Jenny O'Turkey CAFOs, so they designate those specifically. Adam, do you have anything to add to that?
I think, not much other than I believe that those are a bit differently regulated. I want to say that they may have a general permit as opposed to an individual permit because of their proximity. But I would, it's been a bit since I've looked at that permit. So apologies, I'm not more knowledgeable on those specifics.
Okay, great. This is from Jim. What are the setback distances required for pots or unconfined manure piles from private wells and property lines? Are there any watersheds in the state where unconfined manure piles are prohibited?
So those are a couple different questions, and unfortunately, I'm not going to be able to be as specific as I'd like to be on this. I guess I'd ask Hannah to forward that along, and I'd be happy to have that conversation after this, because setback requirements may vary if there's livestock facility siting ordinances, if it's close to some type of like shoreline zoning, or, you know, there are just a lot of specifics at play. And the numbers can vary drastically. So Jim, I'll get back to you on that one.
Great, thank you, Adam. This one is kind of a combination question. We received a few about it. Has DNR ever denied or reversed a permit, especially considering comments from the public?
So the shortest way to answer that question is no. That being said, I can't say that public advocacy, or to the best of my knowledge, no, I should add a caveat. I can say that public comment and public advocacy has, in some respect, halted a permit from being issued. The best example, or the most recent example I can think of, was a proposed hog facility in Bayfield County, way up north near Lake Superior. And what actually happened was there was a call for DNR to put together an environmental impact statement. So as I said, typically for the permitting process, there's a development of an EAQ, which is created by the CAFO, the applicant. And instead, there was a demand that there be more environmental review because of, you know, the potential ramifications of putting a CAFO so close to a Great Lake. And DNR gave in to that public pressure and required that an EIS be put together. And at some point during the process, because of you know, a number of factors I may not be aware of, but I would imagine that some of it had to do with the pressure and the ultimate findings that may have come out, the applicant stopped submitting documents to DNR. So the permitting process just died, for lack of a better term.
Okay, well, this one kind of goes off of what you were just saying. We had a question that is, does the EAQ carry the same weight as an environmental impact statement?
Weight? Yes. So the idea is under a different law that I just didn't have time to get into tonight, but there's Wisconsin's Environmental Policy Act, WEPA, that requires that agency actions that have a significant impact on the human environment engage in environmental review, for me not remembering the exact quote or the exact language. And so this is the idea that part of the permitting process is reviewing the environmental impacts of the operation and determining whether or not the permit or the agency action complies with WEPA. And so an EIS requires more. It is a more in-depth environmental analysis. An EAQ is a less in-depth environmental analysis, or is less rigorous. It requires less underlying data. However, both of them, the result would be a determination of whether of a compliance with WEPA, essentially. So they are both meant to, you would need one or the other, and just currently for the default permitting program for DNR, for CAFOs, they just use the less rigorous process because of the way our regulatory code is written on that front. So they carry the same weight, but they have different rigor levels.
Okay, great. That's a good way to put it. Thank you for that. We next have a question from Carly. Does the runoff management and Wisconsin Administrative Code address agricultural stormwater runoff that is exempted in the Clean Water Act?
So this is the answer to this one is similarly no, or it does address it, but it also has the same exemption. And for those of you maybe on the call not necessarily wholly understanding what that question is, it's this idea that if an entity, a CAFO, spreads on a field in compliance with their nutrient management plan, and then there is rain, the runoff from that field that was applied in compliance with their permit and the nutrient management plan is essentially exempt. It's not considered a discharge from that operation. So that's typically how you see runoff from fields make it to surface waters to create those phosphorus exceedances and algal blooms. You see rainwater washing off manure or waste, or fertilizer in some instances. And Wisconsin has a similar exemption, essentially, that they don't consider that runoff a violation of the permit, or if applied correctly in compliance with your NMP, they don't consider it a violation of the permit, nor do they consider it kind of regulatable discharge.
Okay, great. Next question. At the beginning of a contested case, does the state regulator try to negotiate a settlement between the CAFO and the party making the appeal before going to an administrative court trial?
Yes, so this is a bit of a quirk of the administrative review process. There's not a deadline by which DNR has to forward the petition along. There's a deadline to submit that petition to DNR, and then DNR kind of has the latitude or the discretion for when to forward that along. And oftentimes in those instances, in addition to reviewing the petition itself, DNR may request clarifying changes, but also may have meetings with the appellant, the petitioner, to see if they can come to an agreeable term and essentially rescind that petition. It wouldn't just be the applicant, right? If MEA were to challenge a permit, DNR would have the authority to have settlement discussions before forwarding along the petition to an administrative law judge or the divisions of hearing and appeals as well. But it is a practice that they engage in, at least a single kind of determination as to whether settlement would be a feasible option.
Okay, great. Do you know of an air sampling lab that will allow a private individual to obtain air sample canisters to help figure out what is in the air on their private property?
I don't. I've heard of different forms of air testing, but I am unaware off the top of my head, at least, of where one could go for those canisters. But similar to Jim, if I will get back to that, I'm sure I can find out. It's just I have not had as much experience with household air sampling.
Okay, great. Thank you, Adam. Next we have is when you say local control, are you referring to towns or counties? Do most towns have financial resources to defend themselves if drawn into litigation due to permitting rules?
Sure. So I typically think of it as both. Certainly counties and towns both have regulatory bodies that have the capability of passing some level of ordinances. Oftentimes in certain areas of the state, towns are a little bit more averse to passing zoning ordinances, and counties may be a bit more interested in zoning. But livestock facility siting, if we're talking about that specifically, can function both as a zoning and a licensing ordinance. I think that question, though, highlights one of the concerns that often functions as a threat that then limits action, which is the threat of litigation is wielded even if litigation doesn't arise, for the sole purpose of curbing efforts from local communities and having a responsive local ordinance. I've seen it wielded both at town and county levels. I can't speak to the resources that a town has, because I think it varies quite a bit by towns. I've heard town boards say that they have limited resources. I've also seen towns be represented by attorneys that may live in the area that are just interested in supporting it at a reduced cost or something like that. So certainly there are instances where the towns have taken it upon themselves to push back and litigate the issues. I didn't get a chance really to get into it, but the 5 or 6 towns up in Northwest Wisconsin signed an agreement, right? An intergovernmental agreement. And by that combined capacity or combined effort, you may see increased capacity to respond to those threats as well. So there are certainly ways to kind of better facilitate or better prepare yourself for the pushback you'll get or the litigation that may arise. And I'm happy to talk about that further with local governments. I've appeared in front of county boards and town boards to explain that the threats that they're receiving are not real threats, unlikely to lead to litigation. And so it's something that we keep an eye out for and try to address when we hear about it as well.
Great. Thanks for explaining that, Adam. This next question, I think they're referring to WIPDs. is there a special petition form that needs to be submitted to the DNR?
For a WIPD's permit, or I mean, it could also be for, I'll address a couple different ones. So if you're asking for a public hearing on a proposed CAFO WIPD's permit, so we're still in that realm, but during the comment period, you want a public hearing, there's not a form. You can send the comments to, or the request to the named individual in the draft notice, or the notice that accompanies the draft permit. And like I said, if they reach a critical mass, they hold the hearing, and they have the discretion if only a few people make that request. Now, if you're talking about a petition for a contested case hearing, you do kind of reach there being, I don't know that there is a form, but there is a format by which the petition needs to be submitted or filed. It's in state regulatory code. There may be examples of it online on our either on our website from past versions of our contested case hearing petitions, or on in the code itself or on DNR's page. I can look that up, and I'm happy to provide examples where they'll be helpful. But I'll just note that it's a bit more formulaic for that process rather than the petitioning for a public hearing.
Okay, great, thank you. Next question: does the WIPD's permitting process take into account cumulative effects of surrounding existing CAFOs when modeling environmental impacts?
So that's an interesting one, mainly because it's something that we've brought up recently. You think about it in, as you saw, the northeast portion of the state in particular, where you see 17 CAFOs in Kewaunee County and 22 CAFOs in Manitowoc, and you just see this aggregation in a region that is already relatively confined geographically with minimal, ways to move in or out. It hasn't necessarily been an effective avenue for us raising those comments has not resulted in something yet, but it hasn't been litigated or ruled upon. And the language that DNR relies upon to set those standards is that they have the authority to set terms and permits that are necessary to ensure compliance with water quality or groundwater quality standards. So that's what we argued in the Kinner case was that's a broad but explicit delegation of authority. They were empowered to include those terms. And one of the things that we argue that they should consider is the capacity or lack thereof in certain regions to actually be able to spread or manage those contaminants. So it's something that I don't foresee us stopping making the argument for, especially as more data comes out. I co-authored a report out of the Environmental Working Group last year that looked at a few different regions of the state, and just the overabundance of nutrients, phosphorus, nitrate, and potassium that existed via both fertilizer and manure in those areas. You saw places that just more was produced or brought in than they could possibly feasibly spread on fields. And so it's an argument that we're going to continue making.
Okay, well, I think we probably have time for two more questions. Unfortunately, there's so many, but I think we've gotten through a good chunk. So this is kind of a combo. I'm bringing a few questions into play about nitrate pollution, and specific about the map you showed earlier. I will say I did some searching while Adam was presenting, and I think that map is from 2013, so a decade ago. So just everyone keep that in mind, and I think that answers a few questions. But this next one is still about nitrate contamination and nutrient contamination. So this person is saying, that groundwater infiltration takes a long time. So what we're actually measuring in wells today is actually likely from multiple decades ago. What are your thoughts on this? How accurate is our data these days?
So I think that is, to some extent, an oversimplification of the issue, respectfully. I think one thing to note is areas like Kewaunee County in particular, but northeast portions of the state, we had special administrative codes passed to recognize that in that area, they are characterized by karst topography, also called Silurian dolomite. which is typically characterized by fractured bedrock. And in those places, the bedrock is really close to the surface. And so you don't see that in some places that it is decades old application or abundance of nutrients that are infiltrating into the aquifer. What studies have shown are much quicker than that, days, a day. One could spread in the morning. I think there was stories coming out in 2012, probably before then, certainly after then, discussing the fact that people that lived next to some spreading fields, spreading on them would be in the morning, and an hour later they would have brown tap water. And when you try to test it, if the spreading stopped, the next day they had clear tap water. And so I think in certain areas there is a much more direct transport to groundwater, and then in other areas it may depend on how porous the soil is or how deep the wells are drilled. In other areas we've seen that it's a significantly sooner time. Areas like the Central Sands. I can't speak to every region, and certainly some places it is a longer timeline for transport down. But I think that I wouldn't generalize it in that way, and noting that there are some places that are dealing with much more recent applications, that are actively contaminating their wells.
Okay. I will tell everyone there are so many questions, but MEA is trying to be here for you as well. I'm going to do one more and then kind of close up. But this next one, we've gotten two of them. Is it possible to challenge a CAFO permit if it was passed by a local zoning board? So I think what they're getting at here is some of the local government control and
Sure.
related to zoning.
Sure. This is an interesting question as well. So yes, neighbors, so if it's a livestock facility siting application and permit, there is language to challenge that in the regulatory code. That appeal goes to the livestock facility siting review board. So not an administrative law judge, not a court, but another kind of overseeing body that's made up of a few volunteers, and is a body or a branch of the Department of Agriculture, Trade and Consumer Protection. I say it's an interesting question because that board largely hasn't met. I don't know that they've met in over a year and a half. There just haven't been challenges to many livestock facility siting ordinances. And a lot of the terms for those folks there are expired, and there are some open seats. So that's just an interesting body, something that we've been acutely aware of, but we haven't seen a challenge to that in a while. I do believe that there is a CAFO challenging a livestock facility siting permit that went to the livestock facility siting review board and is now working its way through the court system. So there may be more news on kind of that process and challenging local permits in the future. But yes, there is an avenue to challenge it, and it's a peculiar or particular one to that specific law.
Great. Thank you so much, Adam, for indulging all these questions and many more. For those that are still on, we did record this webinar. It will post it to MEA's YouTube page. I will also be sending it out to all registrants, a link, and as many links as I could send during the chat. I've got those, and we'll include that in that follow-up email. Expect that in the next couple of days. So you will have this information, and you will have this webinar again. Again, we are Midwest Environmental Advocates. I'll give Adam any last thoughts.
I really appreciate the questions. It's a big group of people, and I hope that you found some use for it. And MEA and myself are happy to continue to be a resource. So please don't hesitate to reach out. Like I said, we run an intake line, but I'm also available via email, and I'd love to kind of continue discussions if anyone has any questions for me.
Great. Well, thank you all for joining, and thank you, Adam, and everyone have a great night.